And now I would like to invite Professor David Sehnálek from Masaryk University deliver his presentation entitled Sharenting from the Perspective of the Right to Privacy. Kids, be careful what your parents do on the internet.
So, ladies and gentlemen, first of all, I would like to thank the organizers of the project of this conference. And I have to say that the whole idea of this kind of cooperation is great, and it's even better that you were able to materialize it in practice. Well, as you can see, the topic of my contribution is similar to Marta's topic. I thought that I would be inventive. Apparently, I failed in this regards. Well, since the topic is similar and my conclusions are almost the same, I think that I'm done, and we can go and have a lunch. But I will try to add something new in my contribution. Well, I would say that a certain specificity of a cyberspace is that children often have no or very limited access to the internet, and as we have seen already, yet they are often present in cyberspace indirectly through the actions of their parents. So the problem which we have seen here already in Marta's contribution is that children do not have full or maybe control at all over how they are presented in cyberspace. They cannot influence the information that is published about them on internet, and not only in terms of what they do or say, but also in terms of their photographs and videos. Their parents are in full control, and unfortunately, quite often they do not seek their children's opinion. Well, in many cases, due to the age of children, this is not even possible. So the age, yeah, that's the question. So to me, it seems that as a result, children often effectively lose their status of a subject of law, and become a mere object in cyberspace. And this object is then handled by the child's closest relatives. And these are the people who have the closest ties to them and who should naturally look after and defend child's best interest. I know that I'm now playing on your feelings, but I do it on purpose because of my conclusions. So the phenomenon we are speaking here has its name. Its name is Sharenting, from the combination of two English words, sharenting, sharing and parenting. And I will first start with a definition of sharenting. What defines sharenting as a phenomenon is the fact that information about children is shared by their parents. I would say that the form in which the information is shared is, in my opinion, irrelevant. Probably we can say that sharenting in itself, if done to a reasonable extent, and if the content of the information is also reasonable, is not necessarily a negative social phenomenon, and I will address it later, but it may easily become one. Typically, the systematic and excessive sharing of information or sharing of potentially problematic and sensitive information that directly interferes with child's personal rights, that's something problematic. And sometimes in scientific literature, you can even meet another term like oversharenting to distinguish between something that might be legal and something that is illegal without any doubt. I've got some pictures which I found on the internet, and I have to admit that I have not been as cautious as Marta. I thought it's a publicly available material, and I'm covered by statutory license, scientific license, but yet now I admit that proportionality might be a problem, so I will come quickly back, just to solve it somehow. But the parents are quite often willing to share things that they consider to be funny, and they don't realize consequences. Those pictures I had here, you can find them on Google if you try to search for them funny pictures with kids. Well, and it's it's a problematic. It may not be problematic now, but it may become a problem in future in later children's life. The problem is that children themselves can be cruel. They are little beasts, that's the fact. They can easily misuse information that is freely available in cyberspace and use it against the other in bullying situations. But equally freely available information can put children's lives and health safety at risk. And there are many practical examples of sharenting. It can take a form of sharing photos of a child or videos of a child or situations where funny stories from the child's lives are shared, child's misspoken words, humorous catchphrases, silly dresses, and many others. I guess that if you have Facebooks, you all got that friends who share this information. And I try to systemize this phenomenon, and it seems to me that four basic situations or variants of sharenting are typical. Direct sharenting under the identity of the parent. This one is, I would say, most common on Facebook and other social media. The second one is direct sharenting, which is implemented by the parent under the identity of the child. So the child has no access to its profile, but is presented, and the parent is sort of a manager of a child. The third one represents indirect sharenting, where parents actively create conditions for the child to share the information. This is typical, for example, for YouTube, where this is mostly done for profit. And another situation is an indirect sharenting, where the parent does not intend to disseminate the information about the child, but in fact he does so. That would be, for example, a situation which can be demonstrated on a TV show, which is also available on the internet in the Czech Republic. Its name is Wife Swap. And I don't know if you have the similar thing in your countries, but they choose two families, usually absolutely contradictory when it comes to social background, and then they switch the wives between the families, and you have all the information about the life within the family, including the situation in which the kid lives, which is something unbelievable to me. Legislation, as we have seen, regulating sharenting is multi-layered, and I will not deal with the EU and international level as it has been already introduced. I will skip into the Czech legislation, so you know how this problem is regulated at the Czech level, but I have to say that the Czech legislation follows the standards which are envisaged by EU and international law. And in case of sharenting, two main areas of regulations are concerned, the one in civil law and the one in family law. The first is the protection of personality, which includes protection of likeness and privacy. And in Czech Republic, this is regulated by a civil code. And the addresses of this regulation, you can see it on a slide. The addressees are people regardless of their age. Protection of image and privacy is therefore quite logically granted also to children. And the protection of image and privacy is conceptually based on the fact that any interference presupposes either the existence of a consent of the person concerned or justification on the basis of a statutory license. The legislation and the civil code also reflects the reality that the child is not capable of is capable only of making limited decisions about his or her own affairs. Until a certain age, a child is de facto not able to act on his or her own and share information about his or her privacy. So similarly, he or she is not able to give the consent envisaged by the legislation protecting image and privacy. And the answer to the question of who can act and under what conditions, and if necessary grant consent, is given by the second relevant area of regulation, by the area of family law. This is regulated now also by civil code, which regulates the parental responsibility, as you can see on this slide. And according to this provision, it is basically the parent who shall act and decide. And one important thing follows from this regulation, and Marta was talking about that. It's the quality of the relation between the parent and the child. But what is important is that in most cases, parents do not need direct child's consent under the Czech law. Since parents disseminate information about the child in the capacity of a representative of the child. So the consent is given by the law itself. However, I would say that this cannot lead to a conclusion that sharenting is something permissible. That would be an oversimplification. Since, and again, from the viewpoint of sharenting, it is the quality of the relation between a parent and a child that matters. The legislation in the Czech Republic has historically evolved to place increasing emphasis on the legal status, benefits, and interests of the child. So in defining the role of parents, you can see that the legislation in defining the role of parents, the legislation regulating the parental responsibility highlights that they should care for the child, which means taking care of child's health, emotional, intellectual, and moral development and protecting the child. So the term care is important here as it affects the quality of the relationship and suggests that the parent does not have the position of an absolutist ruler over the child. Neither parent has the status of pater familias with unlimited patria potestas as it used to be in history. So, and these premises are materialized in another provision of the Czech Civil Code, according to which parents exercise the parental responsibility in the best interest of the child. So here we can see that Czech Republic is trying to fulfill its external commitments under international public law. And I believe that this is the area where parents make most mistakes when sharing about information about their children on the internet. They fail to understand the quality of the relationship with the child and the fact that he or she is not an object, not a property, and therefore cannot be, arranged, photographed, and shared publicly in the same way as they photograph and share their lunches in restaurants, a new car, snapshots from holidays, and so on. So to summarize, the regulation contained in the Civil Code implies that a parent can decide that a certain information about the child, like photographs or a video, can be shared publicly. However, the strict limit here is the best interest of child. And a parent may only share information which is consistent with child's interest. Well, and I question myself whether there, can ever be a situation where sharing information about the children on internet is in accordance with its interests. Well, I did some research on that, and I found an article by Claire Besson, and she gives some, answer on this. She lists a number of benefits. You can see them on this slide, and I'm not going to read it, but I would personally divide those reasons which he mentions into two categories. The first are those that directly benefit the child, to promote the child, in its career, in its success. I have found a situation where a profile on Facebook was a way to help children with the Down syndrome to, socialize a bit and so on. So there might be some situations where the child may have a direct benefit. And the second group, which was identified by Claire Besson, represents those situations which benefit parents in the first place, but children may benefit from them secondary. That's the things which are related, for example, to parenting itself and so on. I would say that also in case of sharenting, the intensity matters. Moderate sharenting will not be problematic, and by that I mean classical situations like where you share information about a child which is in principle neutral and which is shared within a limited group of people like the family, close relatives, with minimum informational value about the child and so on. Or if you report, the success of the child at a school competition and so on. Nevertheless, I would say that even here, restraint and caution are appropriate as the problem is time. And I will again use a picture. Well, these are not children anymore, but that was the first picture which came to my mind. Something that has been absolutely normal back in the 80s or 90s may be strange nowadays. This is a picture which is quite famous, probably have seen it as well. It became a source for many memes and for a number of ridicule on the internet. But on the other hand, I remember that I was, wearing the same sweaters, sitting in a similar table, doing the same thing back then, 20 years ago. So time might be a problem. Hairstyles, dress styles, look, which was absolutely normal back then, may look bizarre nowadays. But the information stays on the internet. It will be there forever. So even in a situation where sharenting is harmless or even beneficial in its consequences, it is always necessary to respect the child's opinion within the scope of the Czech law, if, of course, he or she is already capable to formulate and express it reasonably on the issue. The Czech Civil Code provides that parents shall consult their kids and take their opinion into the account. But as Marta said, the problem is that there is no specific age limit. Of course, that's not possible to set for all situations. So the crucial thing is to determine the age at which the obligation to consult the child arises. The law does not explicitly set it, and the determination of a specific age will be very individual and will always depend on the maturity of the individual child. In any event, the limit in Czech Republic when it comes to GDPR is 15 years, but I would say that that's a different area of law. If I focus directly on a civil law, there is no such limit, but de facto, Facebook and other social networks block people younger than 13 years old. I believe that the age limit of 13 years, which many social networks allow children to engage in, is too high. In fact, children become aware of the existence of social network much earlier. Well, I would say 8 to 9, but yeah, maybe even earlier. So that would be probably, the age where we would aim. And parents shall, according to me, always take the child's possible consent with a pinch of salt. A child at a young age may not be able to fully appreciate the consequences of his or her actions online. I was referring in the beginning to YouTubers who do it for money with the aid of their parents. I know about several of them who now regret their actions, who have erased their accounts since something that was funny back then is limiting their career nowadays. So I think that when it comes to parents, refusal to share the information by a kid should always be respected. and consent in turn subjected to critical evaluation. Which brings me to conclusion. Well, only a few days ago, my friend published this picture on the internet. It is the only friend of mine who has done something like that, trying to protect the privacy of his kids. On the other hand, I question myself whether this picture is necessary at all. Well, when it comes to protection of the interest of child in the Czech Republic, the protection is primarily ensured by state through its own bodies. We call it OSPOD. It is a body for social and legal protection of children. And this OSPOD has quite extensive competencies, which would conceptually also include the problematic of sharenting. But I believe that this authority is unable to help us. They can assist with everyday situations in terrain, in families, but they do not have the capacity to follow what's happening on the internet and advise there. Marta has mentioned also children's ombudsman. We don't have anything like this in our legal system, although there are some voices which call for introduction of this institute. Slovak law, the closest to the Czech law, has established such an office, so I checked it. And it seems to me that its competencies are limited. They have considerable limits. So I don't see a children ombudsman as a solution to the problem either. It may help, through cultivation of the relations of society, but that's only an indirect help. And in my opinion, the problem cannot be solved by state. I simply don't believe in that. It would be probably potentially damaging, as it would probably weaken the role of parents within the family. On the other hand, maybe the state may contribute through education, at elementary and high schools. So we change the thinking of people. But still, I think that this is rather unrealistic and idealistic approach. Where I think that might be a solution is in case of social media themselves, since they've got all the necessary tools. They can filter pictures, they can warn parents, you are sharing too many pictures of young kids. The technology may help here. The thing is that the social media, and we all know it, we are using them for free, but they are not free. We are paying by data. And in the case of Sharenting, we are paying by data of someone else, of our kids. So they do it on profit, and they should at least restrain themselves to a certain extent, since they have the technology. And to conclude, I have to confess that when I started putting my contribution together, I went into it thinking that Sharenting wasn't a big deal. That as a sworn opponent of any over-regulation, I would not argue against the freedom of individuals' choice, even of those, of a parent. But I have to say that during my work, I changed my mind, and I have also reconsidered my own approach to publishing posts involving my own children, although they were already considerably restrained before. And that's it. Thank you for your attention.